Hello there, today I want to talk about discharge of contract. Discharge of contract happens when parties to the contract are released from any obligations arises under the contract. Contract can be discharged in 4 ways. The first discharge of contract is discharge by performance. It is the most common way to discharge a contract. A contract becomes discharged through performance where both parties have fully performed their contractual obligations. If one party does not fully perform the contract, this will amount to a breach of contract, may claim for damages unless the contract has been frustrated. For example, Jack agrees to sell his car for an amount of 50,000 ringgit to be paid by Sarah on the delivery of the car. As soon as it is delivered, Jack pays the promised amount. As a result, both parties have fulfilled their obligation, thus the contract is discharged by obligation. Secondly, is discharged by agreement. Contract may be discharged by agreement when parties to the contract agree under free consent to discharge obligations from the former contract. For example, we can see Mark is meeting with Emma to discuss about their former agreement. Mark owes Emma 50,000 ringgit and agree to pays it within a year. Subsequently, he loses his job and requests Emma to accept 30,000 ringgit of final settlement. Emma agrees and they make a contract due to mutual consent. This discharges the original contract due to free consent. Next, is discharged by breach. Breach of condition will enable the innocent party the right to repudiate the contract and claiming damages. The innocent party doesn't have to wait for the breach of the contract if the party already indicates their intention to not perform their contractual obligations. This gives the innocent party the option to sue immediately or continue with contract and wait for the breach to occur before bringing to action. For example, in Chu Yin Lu vs. Visuvalingampal, the court allows a contract to be rescinded when employer fails to pay wages once in every 2 weeks as promised to the employee. Lastly, is discharged by frustration. It takes place when there exists a change in circumstances after the contract was made which is not the fault of either of the parties. When a contract is found frustrated, each party is discharged from future obligations under the contract and neither the parties may sue for breach. In Section 57(1), an agreement to do impossible act in itself is void. For example, in Taylor v. Caldwell, contract becomes frustrated when a music hall burnt down. The fire was unexpected and it was neither anyone's fault. A contract will not be frustrated where it is more difficult to perform. Impossibility of performance is the fault either parties or where the frustrating event could be foreseen. In Kudan Sui v. Chan Chao He, plaintiff has right to claim damages for breach, since the storm that passed through was not too stormy. The storm can be categorized as natural disaster that able to frustrated the contract. Next, I would to talk about acceptance. In Section 2B Contracts Act 1950, when to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. An offer can be made to one person, to a group of person, or to the whole world, but the above provision shows that only whom the proposal is made capable to accept. In Bolton vs. Jones, the defendant does business with one particular trader. On the day when defendant's order arrived, the trader has already sold his business to plaintiff. Plaintiff sent the defendant's goods as ordered, but the defendant refused to pay. Plaintiff then take action against defendant for breach of contract. Court held that plaintiff cannot take action because plaintiff has no right to accept an offer which was not directed to him. Next, Carlisle vs. Carbolic Smoke Wall, where an offer is made to the whole world, then anyone who knows about the offer is capable to accept. For example, Aaron offers to buy Mia's car for 40,000 ringgit and Mia accepts such an offer. Now, this has become a promise. Next is term of acceptance. In Section 7 Contracts Act 1950, in order to convert an offer into promise, the acceptance must be absolute and unqualified. Then, be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. In absolute and unqualified, if an offer is accepted by an offeree but with new terms, then it is not acceptance. It is an counter-offer. In Hyde vs. Wrench, defendant made an offer to sell his estate to plaintiff for £1,000 of sterling. Plaintiff agreed to but for £950. plaintiff sent another letter stating he agrees to pay the original price when he receives no answer from the defendant, but the defendant refused to sell. It was held by the court the plaintiff no longer can accept the original offer. The original offer destroyed when a counteroffer has been made. Then, be expressed in some usual and reasonable manner. If the offerer does not prescribe manner of an acceptance must be made in some usual and reasonable manner. Next, if the offerer has prescribed manner in which the offer shall be accepted, then it must be done in that manner. Lastly, if offeree fails to accept in the manner prescribed, the offerer must within reasonable time after the acceptance is being communicated by him. Next, communication of acceptance. In Section 4.2a, communication of an acceptance completes as against the offerer when offeree put the acceptance letter in a course of transmission. Then, in Section 4.2b, communication of an acceptance completes as against the acceptor when it comes to the knowledge of the offerer. For example, when Ali offers to supply Natasha with goods, and then Natasha agreed to all the terms. Natasha writes the letter to accept the offer but forgets to post the letter. So since the acceptance is not communicated, it is not valid. Postal rule. The communication of an acceptance completes against the offerer and is against the offeree at a different time. In household fire insurance v. Grant, defendant has made an offer to buy shares in plaintiff's company. Plaintiff accepted the offer and sent the acceptance letter by post, but it was lost in the post. The plaintiff asked for money because he is facing financial difficulty, but the defendant refused to give. Defendant claims that there was no contract between them. The court held a valid contract exists between them because acceptance letter is put in course of transmission. Lastly, revocation of acceptance and communication of revocation. In Section 3.2, an acceptance may be revoked at any time before the communication of the acceptance is complete as against offerer but not afterwards. In Section 4.2a, the communication of revocation either in offer or acceptance is complete against the person who make the revocation when he put the notice of revocation in a course of transmission. Then, in Section 4.3b, communication of revocation is complete as against the person to whom it is made, when it comes to his knowledge. For example, Harold offers to sell his car by letter to Scarlett at a certain price. Harold may revoke his offer anytime before Scarlett posts her letter of acceptance but not afterwards. Once the acceptance letter has been posted, it cannot be revoked.